Good evening again, Mr. Speaker. Mr. Speaker, I rise to support the Deeds Registry Amendment Bill 2021 as proposed by the Honorable Attorney General. Mr. Speaker, when we were dealing with the Power of Attorneys Act a few minutes ago, I had indicated that there were certain components, which could be three. It related to the people who were actually named in the deed, the power of attorney, which is the donor, the donee, the person getting the power and the person giving the power. And there was, of course, the notary. So there were obligations on all three of those persons. The third part and the last part is the registration of the document in the deeds registry. Now, it would be useless. It would be downright foolish, if I say so, Mr. Speaker, that you would go to all that trouble that the donor of the power has to identify himself, the donee, the recipient of the power, has to provide identification. The notary is obliged to examine it. The witnesses are required to give statements. But you don't take all of that information and file it in the deeds registry so there is a permanent record. It would mean that everything you had done to preserve the sanctity of the document, to make it safer, you would have defeated at the most important step, which is where the permanent record is created. The files in the deeds registry are permanent record, Mr. Speaker. There are files in there that are there for more than a century. Now, it would all go to zero if it were not required that the people, the staff of the deeds registry, register all these documents. So the amendment, respectfully, Mr. Speaker, requires that a power of attorney shall not be registered in the deeds registry, which is more of mandatory language, that it shall not be done, unless what is attached to it, photocopies of 2 photograph identification documents of the donor and donee, separate witness statements of each witness that would have witnessed the deed itself, and it has to be stamped by the notary. It has to be a seal, which is a stamp, and he has to sign it. Now, if there was not this final part, Mr. Speaker, then that would be the gaping loophole to it all. Because what would happen is the people who are responsible for creating the final record will not have the record. How do you go back and say that the donor of the power provided the information required? How do you go back that the recipient of the power provided the information? And importantly, how do you hold the notary's foot to the fire that he did not do his job? If you do not have the entire folio of documents that are required and filed as a permanent record in the registry. So, Mr. Speaker, as night follows day, this is required to give effect to the amendment that has been inserted into the Power of Attorneys Act. The amendment which gives protection to the citizens for when that document is used. Now it comes full circle. The registry must participate in keeping power of attorneys relevant, sacrosanct, and secure. The deeds registry must do that. Now, Your Honor, The complaint is two forms of identification is difficult. Your Honor, we're getting to cross purposes. The purpose of the legislation was not to make anything easy. There is no mischief in Guyana with the law needing to be easier. The mischief is it is being abused fraudulently. So you don't want to make it easier. You want to make it respectably difficult. Now, I use the terms respectably difficult, Mr. Speaker, to convey if the person who is going to be the recipient of a power does not have two forms of identification, I would respectfully suggest that he is not the person that should be the recipient of such a power. But I don't cast aspersions. I don't wish to say that. But, Your Honor, everything that requires documentation requires a level of documentation that is deemed secure. Mr. Speaker, in the old days, I'm told you traveled with a document that you wrote up with your name. It is the reason why so many of our citizens who have traveled to Guyana have names that are quite unusual, anglicized names in the case of those that came as indentured servants. But, Mr. Speaker, I digress. You had at that time a different level of requirement. Years ago, we traveled with passports that weren't machine readable. But society has moved on. The requirement of having machine readable passports is, the wisdom of it is seen. The requirement followed. Mr. Speaker, do not let us confuse what the Power of Attorney Amendment Act and the Deeds Registry Act is designed to address. The mischief, Mr. Speaker, is not easy. Is not to make it easy. The Attorney General has said to this House, as is accepted, laws are breathing, living things. If it were to be discovered that insurmountable hurdles are being presented in the process by having the requirement of two forms of ID, then Parliament, the Attorney General, can bring to this House a bill to correct it. But at the get-go, what we are trying to do is make it more secure, not make it easy. Make it more secure in a realistic way. Most people have an ID card because you would have voted, presumably, and you have a passport because you would have traveled. You have a driver's license because you would have driven. Maybe my colleague, the Honorable Minister, Mr. Shearer, says she doesn't see the value of driving, perhaps, but Mr. Speaker, everybody's got two forms of ID. And if you don't have two forms of ID, maybe this is time that you should. The mischief is the fraud. The remedy is to put a system in place that will deal with the fraud, not put a system in place that will do nothing to alleviate the current difficulties, because it is too easy, and it is equally easy so that you can circumvent what is the mischief being sought to be prevented. Mr. Speaker, that is the simple response to those who say that it is too difficult. The simple response is the government has to look after its people. This is a problem. The fraud relating to power of attorneys is a problem. Mr. Speaker, It is respectfully to the member on the opposition side who said that it has a bearing on the registration of births and deaths and the legislation that has passed. It is a non sequitur. It relates to different things. But if you were to take it to its logical conclusion that it was somehow made easier, despite the requirement of the people who, and the reputation of those persons who must give you that declaration, if it was somehow made easier, then the argument would not apply that it is difficult then to get your two forms of ID, because then you would be well on the path if it were made easier. So the argument, respectfully, is non sequitur. It makes it, not only does the argument itself not make sense, it has no applicability to what the House is considering now. What is the mischief that the House is trying to address, and what is the mischief that this bill seeks to correct? Respectfully, Mr. Speaker, with those few words, I commend Bill number 16 of 2021, the Deeds Registry Amendment Bill 2021, and I support the amendment that it proposes to our Deeds Registry Act. Thank you very much, Mr. Speaker.